Hi, everyone. I'm attorney Donna DiMaggio Berger, and this is Take It to the Board, where we speak condo and HOA.
Okay.
One of the things that the vast majority of community association boards will face at some point is a legal dispute. If a dispute cannot be resolved amicably, the parties will likely resort to either alternative dispute resolution or litigation. The idea of doing legal battle can be intimidating to even people experienced with the process, but today's episode will provide insight on what goes on in a courtroom or mediator's office without the accompanying heartburn of real litigation. Our guest today is former trial judge Jeffrey Streitfeld. Judge Streitfeld has spent 5 decades as a civil trial lawyer in Florida. He was elected unopposed to the 17th Circuit bench in July 1990 and was reelected 3 times without opposition. He served as a trial court judge for 24 years and presided over nearly 400 jury trials. After his retirement from the bench, Judge Streitfeld was certified by the Florida Supreme Court as a Circuit Civil Mediator. My firm, Becker, once bore his name when it was known as Becker, Poliakoff Streitfeld. Back then, Jeff was at the forefront of creating new case law for community associations in Florida. Today, he's helping people throughout Dade, Broward, and Palm Beach counties reach common ground in their ongoing disputes. Jeff, welcome to Take It to the Board.
Well, hi, Donna. Nice to be with you today.
We are so honored to have you on the program. I want to start out, Jeff, by asking, can you explain the different types of mediation for our listeners?
Well, mediation is available to resolve any dispute. It can be a civil dispute. It can be an estate or probate dispute. And there are times when even there might be a criminal component to the dispute as well. So there is no limit to the type of problem that a mediation might resolve.
Are there different types of mediation? For instance, I saw something regarding mediation that evaluates the problem, or so it's referred to evaluative mediation.
Well, more likely the way to look at it is what kind of mediator do we want? Do you want someone who is actually going to be active in helping each side evaluate the strengths and weaknesses of their position, as opposed to a mediator who is just merely taking a message from one party to another and sort of like Harry Potter's owl, flying into the room, dropping the message and flying back out again. That is not me. In fact, typically at this stage, I am requested to mediate a dispute when at least one lawyer says, I need your help, because there is no case or dispute where one side is absolutely right, has no issues with their case, and the other side is completely wrong and has all the problems. Everybody has some issue that it should be concerned with. So for me, I do help people evaluate the risks involved in not moving forward with a settlement, having to go to court.
So what are the basic elements of mediation?
There are 2 primary elements. One is that it's a confidential conversation, so people know that they can speak freely and not be concerned about being questioned in a court proceeding about something they said in a mediation. It gives them the opportunity, everyone, to speak openly and freely. Secondly, you're sitting with a neutral person, someone who has no stake in the dispute. It's not representing anyone, but is there to help each side, or multiple parties could be even, evaluate the problem that's being addressed and what could be done to make that problem go away.
So I imagine the communication skills of the mediator are key here.
Absolutely.
We just did an episode with Carmelo Millamachi, and we'll put it in the show notes. And Carmelo is a professional coach, and we talked about the elements of listening and communication skills. I imagine for a mediator, when you're speaking to both sides and you're trying to help them evaluate the strengths of their case, you coming across as a neutral party. Have you ever run into a situation where you've already got people who are pretty entrenched in their positions and they may feel that you're favoring one side or the other? How do you handle that situation?
I tell them, look, if you think I'm only giving you a hard time and I'm being a rah-rah supporter in the other room, you're sadly mistaken. My role is not to be a cheerleader. My role is to point out the problems that you may be facing to help you address them. It happens frequently. And sometimes I'm not successful, because really the key to a mediation is people have to be ready to settle. I can't make them get ready. There are times where I'll meet with someone, any mediator will, and maybe you've only planted a seed that day. They're not ready to settle today, but they may settle a month from now or 2 months or 3 months from now. And the seeds that were planted in the mediation have finally taken fruit. I don't feel like I've been like yesterday, which was I knew going in was going to be a difficult challenge. I know that seeds were planted. I think it very well may resolve, but it did not resolve yesterday.
Sometimes, Jeff, we have boards, association boards in the midst of a dispute, and settlement is possible, but the board members want to go forward with litigation on the principle of the matter, or it may be the owner who wants to go forward on the principle of the matter. How do you overcome that mindset?
It's a very difficult mindset to combat. So much depends on the people. When we first started doing this remotely in April of 2020, I really thought it would be a waste of time. And I reversed myself and withdrew that evaluation, because what makes mediation work remotely is people are feeling safe. They're in their own space. They're not driving to a downtown office, parking in some ungodly garage and paying $40 a day to park their car in a space that was meant for a Yugo. They're in their own home often, or maybe in their own lawyer's office, but still the confrontational aspect of it is gone. So when I have someone who says, I want to fight for principle, I say, well, let's talk about that for a minute. First of all, how long is this going to take? And how much is it going to cost you? And what are the risks of your not being successful? And then what if an appeal is taken from that decision? How long will that take? How much will that cost? Because unfortunately, our litigation system is expensive and there's always risk involved. So there are times when that reality, all those issues, time, money, risk, people will withdraw. But if they're not ready to settle, then they're not.
Yeah. They want to make a point regardless of cost.
That's all there is to it. I mean, I'm not Moses. I can't cast my staff, make the Red Sea part, nor can I have someone say, I know I'm right. There are mediations I've done in 2016 that are still in litigation in 2022. They're still fighting. God knows how much money they spent.
Well, you're not Moses, but you might be King Solomon. So when you're evaluating, I mean, listen, if they're close, where you think both sides have a fairly equal level of risk in terms of proving their case, I assume your advice is one thing, but what if it's completely lopsided, Jeff? What if it's so clear during mediation that you've got a potential winner and a potential loser? Do you still advocate for a settlement at that point?
Right. And because there are a number of reasons why. I mean, for instance, if the side that's stronger wants something from the side that's weaker, the side that's weaker can only do so much. It could never be enough to satisfy the other side, but still, it's all the other side that has a stronger position could ultimately get anyway. Even where one side is clearly in the stronger position, which of course exists, there are reasons to compromise because it's not going to get any better anyway. Court will not resolve that problem beyond what's available today.
And we should mention there's a difference between voluntary mediation and court-ordered mediation.
True. You don't have to go to court to mediate. People can say, you know what, we have a problem. I don't want to go to court. Let's see if we can't sit down and talk about it. They can't settle it. They say, well, let's sit with a neutral third party, see if that person can help us. Because to give you an extreme, about 3 years ago, maybe 4 now, I was in a matter in a mediation in New York involving people and lawyers from New York, but it was in Miami. And I'm sitting with a New York lawyer. He said, at this point, I'm telling my clients, if the amount in controversy is not at least $10 million, it doesn't make sense to go to court. Well, that's New York. That's New York. But the reality is, this afternoon, it's a dispute over maybe $50,000. Well, you don't go to court and litigate for 2 or 3 years over $50,000 because you're going to spend $50,000.
Unless you're doing it on principle, Jeff. And then I guess
principle is cheaper. It's the same cost. And the problem, of course, particularly exists within the community setting. In 1986, same year I hired Ken Director, I was a speaker in a Florida bar continuing legal education seminar on alternative dispute resolution. Mediation was barely used at that time. And why did it become so popular? Why is it so successful? Because instead of a lawyer telling a client, these are all the problems with your case, and the client said, gee, you didn't tell me that 2 years ago. Not when I paid you that retainer, not when I've been paying you. Now all of a sudden I have problems. So the lawyer can, while pointing out these issues, can allow the mediator to take over their role.
So you're the bad guy a little bit, or at least the messenger of bad news.
There are occasionally where there's a lot of love directed toward me, but it's only occasional. Within the community association setting, it's particularly helpful, but also problematic, because if you have someone who's made an unauthorized alteration of their unit, or they've rented without approval, or they're behind in their maintenance assessments, however the community board addresses that, they have to treat everyone similarly. They cannot selectively enforce one against the other. They can't make one deal with one homeowner and have someone in a similar situation, they don't give them the same break. So there's a policy and a restrictive area. That doesn't mean that it can't work. My own experience, by the time I left the firm in 1990, we were already up to 2,000 communities, and I was traveling all over the state. I found that those are one of the areas that were difficult. And the other is, with a board, you're going to have different opinions, multiple opinions, different personalities. So to get them on the same page is also a task for the association attorney that probably should be addressed well ahead of time before you embark upon a settlement offer, a mediation, or court. And of course, then you also have the problem of boards change. Annual meetings result in new board members with new attitudes. So in the community association setting, a fair mediation is better than a court victory. For instance, if the association ends up spending $40,000 in winning its case, and the trial judge who determines a reasonable fee only awards $30,000, now the association's out $10,000. And that's not a good business plan. So that doesn't work. And from the unit owner or homeowner's point of view, the same thing holds true. First of all, it always used to, from my experience, upset homeowners or unit owners who are being sued, knowing that they're still paying a part of the attorney's fee for the association.
Unless their attorney is smart enough to put in the settlement or the order that they are exempt from that award. And we're talking about Florida law here, but they can actually put into the order that their client is exempt, but so many of them forget to do that.
I was not aware of that. I'd like you to send me the citation or statute that tells me that I can do that.
I will. I've actually shocked quite a few attorneys who represent owners where they get the assessment to pay for the award, and they say, wait a second, why is our client? I said, because you didn't put it in the order. You have to actually seek that relief.
I try to learn something every day. You're my educator. Thank you for that.
All right. Well, I want to take a step back. For those of you who are still wondering who Jeff is referring to when he said he hired Ken Director, Ken Director is a partner at Becker right now, and he chairs the statewide community association practice. And he was one of Jeff's many excellent hires here years ago when the firm was Becker, Poliakoff, and Streitfeld. But I want to take a step back. You mentioned a few minutes ago, Jeff, about costs. So what would be, when a board is evaluating costs, the differential between mediating and litigating? I imagine it's significant.
Mediation is far less expensive than court. Oh my goodness. I mean, you're certainly still going to have to pay, although you don't have to have an attorney. You don't have to have an attorney.
Okay, now that you said that, I'm going to ask you later to follow up on what the challenges are when either the association or the owner shows up for mediation without counsel.
Well, a mediator cannot give legal advice, period. But you can come close, and I have to come close. I have to tell them, this is your risk. And then if someone asks my opinion, I'm going to give them my opinion. But you don't have to have a lawyer, but people showing up at a mediation without a lawyer makes it a real challenge for a mediator. I prefer not to be involved because I'm concerned that if I'm mediating for someone, they don't have a lawyer, and then as it turns out, they didn't like the settlement, they could file a complaint against me for violating my role as a mediator. And I try to be as risk averse as possible. I've never been sued or had a complaint made against me. I was sued as a lawyer with Becker, because when you do that, sometimes not by a client, but by someone who I sued ends up filing a suit against the law firm. Sued the firm, sued Alan Becker, sued Gary Poliakoff, sued me, because my name was on the firm. One of the benefits of being a named partner. You don't have to have an attorney, but the cost-wise still, I mean, depending on the lawsuit, if you take a look at the need to do preparation in advance of trial, take depositions, do written legal term discovery, obtain all the relevant documents, ask for answers to questions in writing under oath called interrogatories. All the pre-trial preparation in a lawsuit can be very expensive. And then, of course, the trial, the preparation for trial, and the trial expensive, and the numbers over time can really add up. And in some cases, if it goes on if you're in Palm Beach County, they rotate judges every 2 years. So if your case goes longer than 2 years, you're going to have a new judge. And then if it goes past 4 years, you're going to have a third judge whose rulings may change. So we still have the best civil jurisprudence in the world. We're the only country that really offers people the avenue of bringing their civil disputes to a courtroom, either for a decision by a judge or jury, but it's for people, so it's not a perfect system. A mediation gives you the opportunity at a nominal cost to avoid a lot of angst and a lot of money.
As a former judge, I have to ask your opinion about the level of informality we're seeing in terms of the way people are approaching litigation these days and the way they conduct themselves in the courthouse. And without getting political, the Alex Jones case, I've seen some of that footage, Rudy Giuliani in court. We've got people across the board going into court these days, and it's almost as if they're winging it. No preparation. They're saying things that clearly don't make sense. Is this a trend? Is this where we're headed and where we're going to stay, that people take it less seriously?
Well, everything you're just saying, first, I haven't been in a courtroom in a while, but these observations you made, they've always been a part of our court system, and it's up to the judges to deal with that. And some are more proactive and focused on preparation and performance and behavior than others. A lot of it depends on the courtroom. When I sat in the criminal court, I only did that for a couple of years. You could have heard a pin drop in that courtroom. People were respectful, and they understood how important it was to be prepared. But you could walk in another courtroom, a criminal courtroom, and there would be 50 conversations going on. You couldn't even hear the judge, which made no sense to me, because if I were a defendant in a criminal courtroom, I'd want to hear what the judge is saying to people. And so that behavior that you're describing has always been a part of our court system, because there are different judges and different lawyers, some prepared, some not so much. It's unfortunately always been the case.
So the ultimate tool to control your courtroom would be contempt, finding somebody in contempt of court. Did you ever have to do that, Jeff?
Only a couple of occasions. And both times it was when someone in open court made comments to me that were not particularly supportive of my religion, apparently knew my mother very well. Both of those times that I can recall, the person was taken away to the Broward County Jail. One time when I was in the criminal court, it was a packed courtroom. So that person was immediately sentenced. He was already in custody, but I separately sentenced him to a fair amount of time. Of course, his public defender knew that if he brought that person back to me with an apology, that I would take care of that and resolve it, because the person just lost it at the moment. And the second time, the person actually had to hire a lawyer and appeal my contempt citation to the 4th District Court of Appeal, which I knew probably would happen. Twice in 24 years is not bad.
That's not bad, but even those two cases, it amazes me that everyone doesn't understand the consequences that can potentially be doled out in a court of law if you don't conduct yourself appropriately.
Well, look, both instances, these were people that were under extreme stress and just lost control. The courthouse is open to everybody. So you're going to get every kind of person that your imagination could conceive of walking into a courtroom. It could be a lawyer, too.
So how did being a judge prepare you to be a mediator now?
Overall, I mean, it's hard for me to believe. I'm approaching year 50 as a member of the Florida Bar. So the judge part of it adding to the lawyer part of it helps me just focus differently now. Today, I certainly focus on the legal issues. I focus on the factual disputes, which I did as a lawyer and which, of course, I did as a judge. But now as a mediator, I'm focusing more on the person or the party, the company. What do they need to resolve this problem? And that's an entirely different approach. But the combination of being a lawyer and being a judge gives me a pretty well-rounded set of tools to work with to help reach that goal and to connect with the person.
When you do mediation, sometimes are both parties in the room together as opposed to putting them in different rooms and you running back and forth?
And when we were doing them in person, the shortest mediation ever, we never broke out. We all sat in the same room and they started talking to each other, but in a productive way. I just sat back. And within an hour and 15 minutes, it was done. They were fine. They just needed to sit in the room together. That's happened once in roughly 600 mediations. That's happened once. Typically, we're in the room together, to me, as briefly as possible. The sooner I can get people in a separate room and talk to them separately and move back and forth, the better. There are times in an early mediation, which I'm a big fan of, for people to realize, before we embark on this anxiety-producing, high-cost effort in court, can we sit down, maybe with the help of the neutral, and see if there's a common ground? And when that happens, then there has to be, at least initially from the lawyers, a lot of talking, because there hasn't been no one's taken any depositions. There hasn't been any arguments in court. So one side has to then speak at length, and so does the other. But the key is, will you please listen? Because somebody else is going to be listening to this, and you have to keep an open mind. And sometimes those work out extremely well. Sometimes people are just not ready to do that, and so at least you gave it a try.
You'll allow the attorneys to kind of give an opening statement, give an overview of their positions. What about, when you get into it, attorneys who default into litigation mode and want to object to certain things that are being said? That's
rarely where a lawyer will interrupt another. But what is not rare is when a lawyer becomes too aggressive and too argumentative. That makes me very nervous. My approach is I turn to the lawyers as professionals saying, please make the comments that you think will be helpful to move us forward. And oftentimes they will do that. But there's an occasion where a lawyer has said, look, I've prepared these arguments and I'm going to make this position and I can't tell you can't. I have interrupted people when they've been 45, 50 minutes and I can see the other side getting more and more angry about what they're hearing. That instead of moving us one step forward, it's like it's for football fans, instead of 1st and 10, we have a holding penalty. Now it's 1st and 20. And then the person's talking. There's another holding penalty. Now it's 1st and 30. So forgetting about getting a first down, we're going to have to punt.
So the scoop on you, Jeff, is that not only do you read everything because you're a stickler on preparation, you're also a speed reader, according to what I understand. You're there to effectuate a settlement. You're not trying a case. You're trying to get these parties to reach common ground and settle the matter, right?
Correct.
What do you do when you, as the mediator, you've read everything that's been submitted, and yet the attorney, or perhaps his or her client, is going off the rails and saying things that are not true because you've read all the documentation submitted? Would you call somebody out?
No, not at a joint session, but I will when we're speaking privately. I will typically point out to people in the opening that it's entirely possible, if not probable, that at one point your lawyer and I may not agree. And that's healthy. You should listen to that. Lawyers disagree on words all the time. When you have an appellate, the U.S. Supreme Court can take a look at the same record, the same documents, and these are supposed to be our smartest minds. They can't agree because law is art. It's not science. I tell people, don't get upset if your lawyer and I are disagreeing. It's productive because the judge may agree with your lawyer. The judge may not agree with your attorney. And the attorney cannot make up the law, and the attorney cannot make up the evidence. The evidence, and I oftentimes in a mediation, well, let's focus on the evidence. Who will the key witnesses be? Have they been evaluated? What are the key documents? Let's take a look at those. So we'll dig in as deep as we need to actually evaluate the strengths and weaknesses of people's positions. It's a very effective and relatively inexpensive way of getting a clean, neutral view of the dispute. I had one with a very high profile person known throughout the country, and we had a very highly emotionally charged, nationally exposed horrible case. And it was clear that some public statement would have to be published once that resolution was completed. It took 3 months to agree upon the language of the public statement. So
this is a mediation, Jeff, that
right.
went on that long.
Well, the mediation itself was resolved on a Saturday, one day.
Okay.
Then we revisited parts of it 2 months later, and then we had to come up with a public statement. It took a while. So each mediation is different. In the community association setting, that should not happen.
Do you ever have multiple day mediations where it's continuing, or no?
Yes, we might meet for a day, adjourn, come back a month or two later. I've had them run one day and then the next day. Even within the community association setting, it's a matter of public record. There's a case in Palm Beach County by the name of Peramboom versus Perlmutter that has been going on for at least 5-6 years. There are so many lawyers involved, and it all arose out of a community association. It's two people who live in a community. Depending on the community, things can get out of hand, and litigation can take on a life of its own. If personalities are strong, and these are people that are well-heeled, they will fight. They will want to continue to fight. It's like their entertainment.
You said your shortest mediation was 1 day, hour and a half, did you say?
Right. I've had several that have only gone an hour and a half. People were able to reach a common ground very quickly. They were really ready to settle. That's rare. That's very rare.
I'm sure, unfortunately.
The average would be probably 3-4 hours. But I've had many take a full day. I mean, I had one. I was in Miami till 1:30 in the morning. We started at 9 o'clock the previous morning, and they didn't feed us any dinner. So needless to say that it was tense, really tense.
And they pay you by the hour. Both sides split the cost, correct?
You're splitting the hour among at least two parties. So the actual cost is insignificant, typically compared with what the cost would be if you're fighting in court.
What's the longest mediation you've ever engaged in?
2 days.
Okay. Listen, I know I again said how important preparation is for you. What can an association board and its counsel do to prepare for mediation to make it most effective?
Well, the first thing is to get whatever legal opinion you need. Where do we stand on the law? What are our problems? What are the parameters of what we can do to settle if we want to settle? Because, as I said, there are issues with regard to you got to treat people the same. You cannot make different deals with different people with a similar problem. Although with collections, you have a lot of latitude because you have different monetary concerns with each unit on what they can and can't do. That's one, is checking with your lawyer. Two is making sure that the board has discussed it and you've ironed out what differences of opinion there be and reached a consensus as to what the board is prepared to do. Third, who shows up? It is not the more the merrier. It is the antithesis of that. Your best bet is to have a couple of people, preferably no more than 3, attend, making sure it's people who are good listeners, who are respectful, who are patient, and are prepared to spend the time necessary to work through the problem.
Where are we going to find these unicorns on a board, Jeff, that you just described?
Yes.
Patient, good listeners. No, I'm joking, but let's say the nature of the dispute is that the unit owner is claiming the board president is a tyrant. He has reassigned that unit owner's parking space illegally. Do we send that board president who has past history with this unit owner? It's like the Hatfields and the McCoys. They can't stand each other. They happen to be neighbors. So the dispute is personal for the board president, or do we send the vice president or another board member? I mean, what are your thoughts on that?
Well, when it's a personal thing like that, let's say the president agrees not to appear. Then, of course, you want to make sure that he's going to be able to accept a range of possible resolutions to the problem. But then you also have to make sure how the other side feels. The board says, we think it's best he or she not be there. The other side says, no, I want him there.
I want to confront him.
In court, our rules require all the parties to be present. So that doesn't mean they can't be excused as well. But when you have personalities, more likely than not, they need to be there. They just need to be prepared. But there are times where it might be prudent for someone not to be there, but then you need to do a lot of pre-mediation work to make sure that those persons' views are considered and we understand what they may be prepared to agree to or not in a settlement. So it takes a little preparation there as well. So when we're talking about preparation is one, lawyer, make sure you understand what you can and can't do legally, what the strengths and weaknesses of your legal position are. Two, making sure the board is met ahead of time to understand where the board is and we've reached a consensus. Third, making sure the right people who are prepared to be respectful and patient and be good listeners as well as good communicators are participating in the mediation.
And it must be obvious to you in a mediation, Jeff, which attorneys have done their job in terms of selecting the right people and prepping those people on how to conduct themselves, and those attorneys who have not.
Typically, the lawyers do a good job. Sometimes, no matter how good a job they do, they're not going to be able to control their client because it's just the reality.
Very true. What kind of impression does that make on you as a mediator? And I know you're neutral, but it's got to make some sort of an impression on you when you're dealing with a party that's uncontrollable.
I do the best I can. I make it clear, look, you're not helping the situation. I don't agree with your position, but that's totally your case and your call. And if that's what you want to do, okay. I'm not reluctant to be even arguing with someone if I need to.
I mentioned just a few minutes ago a parking space dispute. But what are the most common types of association cases you handled as a judge and now as a mediator, Jeff?
Oh, boy, you name it. Literally every conceivable issue, violations of the bylaws, violations of association rule, board misconduct, election disputes. In fact, I'm running disputed elections. Whatever Chapter 718 or 720 could encompass has come across my desk either in the court or in a mediation.
We always like to tell the story as community association attorneys that the state of Florida mandated pre-suit arbitration, alternative dispute resolution, because of so-called fat cat cases, that the courts were getting clogged by what they saw as frivolous litigation. Is there truth to that perception?
Well, I remember when that first started, the judges, they saw these disputes as something they just didn't want to deal with. An overweight dog, and I believe me, I'd litigated a lot of canine cases, plenty. One of them, still I think good law, Palmer versus Gordon, which we were successful in getting rid of that Cocker Spaniel. Spent a lot of money. It was probably maybe $5,000 a pound. That's what it cost to get that dog out. And that was the first time where that I know of where the defense was raised is that we have a prescription for the dog as a support animal for Mrs. Gordon. That was not successful. Of course, I think the law may have changed a bit on that. So judges did not want to be bothered with these internal fights at all. They thought it was just a waste of time, not beneath them. Get it out of the courthouse. Get it out of the court. I don't want to deal with that. And that's why that happened. And actually, it was my job in part to try to persuade a judge that had that frame of mind. Now, wait a minute. These are major community issues. This is the wave of what's happening in the state of Florida. These cases are important to the people who live there, and they deserve the same amount of attention and concern of anyone else's case. But that's why that existed.
Well, and these disputes have the potential to escalate quickly because you've got people living next to each other. So it's one thing if you're litigating with somebody And, you don't see them every day. You're dealing with them through your counsel. But in these associations, as you well know, these have the ability to escalate very quickly. And we've seen loss of life and personal injury in these associations if there isn't an ability to resolve the dispute.
Yes, because they see each other every day. They may be living next to each other across the hall. They may be parking next to each other.
At the pool.
Right.
I agree with you. I don't think what may seem trivial or frivolous at the outset has the potential to become much more serious if we can't get it resolved.
Yes, it can be who's allowed to go to the pool. Are your guests allowed to go to the pool? Does a baby have to be wearing a diaper? I mean, you name it.
And they're very emotional issues. A lot of them are emotional triggers. Like you said before, when you get somebody in mediation and it's clear that they are entrenched on an issue because it is very emotional to them, that particular issue.
Look, the people that are serving on boards, I truly respect their willingness to serve. They're not getting paid. They're taking on a responsibility that most other people wouldn't do. And it's a thankless job. But unfortunately, there are times where you have people that take that role that really should not be there. They're there for the wrong reasons. They're there because it gives them some power and authority that maybe they didn't have before, and that can be problematic as well. So it's I'm sure continues to be a constant challenge for you, Donna, and everyone else who practices community association law is dealing with the personalities on that board. And of course, it's no different for a lawyer who's representing a corporation. I can recall some really very significant, very expensive lawsuits that were in front of me when I was in the complex division in Broward County Circuit Court, that I could see the general counsel on one side and the general counsel on the other side were the problem. And so who's in authority is always
key. It really is. I mean, listen, when I'm dealing, Jeff, with boards and it's obvious there's an authoritarian figure, typically the president, my advice is to the rest of the board, you've got to participate because you're all going to swim together or sink together. So you need to get together and not just say, leave everything to that authoritarian director on the board. It's a recipe for disaster.
The most extreme example that I can recall this goes back to the 1980s. The Hillcrest community at the time was really very successful. They had 2 golf courses, gorgeous tennis facility. Hillcrest 23 was one of the high rises. And the president, by the name of Arthur Prince, lived directly across the hall from Ben Tobin, who developed Hillcrest, the entire community. And in fact, he promoted the developer lives here. Well, as it turns out, we went to trial in the federal court on their recreation lease. We're not successful, but still I was able to negotiate a settlement. And Arthur Prince, who was the president of the association, was opposed to the settlement. Nevertheless, the board approved the settlement. The unit owners voted in support of the settlement. And then when I went in front of the judge, Jose Gonzalez, the federal district judge, to get approval of this class action settlement, Art Prince led a dissension in the courtroom to the settlement. That's the most extreme example.
I was going to say that must have been a shock. I represent Hillcrest 23 now. Perhaps you don't. There's a brand new board that you're talking about, a board from decades ago.
Judge Streitfeld says a lot.
They're an excellent board right now. But you mentioned settlement, and I wanted to talk to you about that. So if an agreement is reached at mediation, how important do you think it is, Jeff, to have a written settlement agreement worked out right then and there at mediation, as opposed to wrapping for the day and saying we're going to do the paperwork later?
It's highly desirable. Back in the old day when we were mediating in person, and people are doing it again now, I would not leave until there was a document prepared and signed, period. Because people do change their mind. People reconsider. They have buyer's remorse. But today, where most mediations are done remotely, and there are a lot of reasons why it's beneficial to do it remotely, there is always that risk because many times It's left to the lawyers to prepare documents and get them signed. So far, I know of only one instance that it fell apart, but there's always that risk.
Do you do your remote mediations by Zoom?
Yes.
So you can share screen. So I imagine you could say, work up the settlement right now, and you could share the screen and agree on the terms.
Yeah, it depends on the complexity of the settlement. Some can be very quickly documented, but there are other times where the lawyers are totally fine and they have a comfort level, and it hasn't been a problem with documenting it later. But it is highly advisable to document it and sign it immediately, that day before the mediation ends.
Good to know for everyone listening. So last session, Jeff, the Florida legislature changed the law. Condominium disputes and cooperative disputes, there was the requirement to engage in pre-suit non-binding arbitration.
Right.
Okay. And then if you didn't like the arbitration result, you could file for a trial de novo. But last session, the law was changed, and now condominiums and co-ops have the ability to choose mediation as opposed to arbitration. And I know that I went on your website, and I know that you offer to assist with arbitration. There's a perception out there amongst my colleagues and the association boards that mediation is probably the better path to choose, that you're going to get a better resolution. Do you think that perception is borne out by the results that mediation is probably going to render a better result than engaging in the typical non-binding arbitration with the division?
I think the best way to answer this is so much depends on, for instance, who the arbitrator is. If it's an arbitrator who is not a judge, by way of example, but someone who that's their job to hear these disputes and this is their view, if someone doesn't like it, say, well, look, that person's not a judge, and I could go in front of a jury. And I'm not happy with that. As opposed to if you go to a mediator, someone who's authoritative and knowledgeable in the field and can work through the risk with you, I think overall there's a greater likelihood of resolution. Because we have non-binding arbitration in circuit civil cases as well. And I have found that when people go to non-binding arbitration in circuit court and they don't like the result of the arbitrator, they're just going to go back to say, no, I'm okay. I don't like that decision. I'm going to take a second shot, get another bite at the apple. I would always recommend mediation over arbitration, non-binding arbitration. Absolutely.
Yeah, some of the criticisms I've heard, Jeff, is that you can have a similar fact pattern in arbitration. And again, depending on the arbitrator you're in front of, you can get wildly different results.
And also, a non-binding arbitration, it's a summary. If you went to trial, it would take maybe 2 days or 3 days to present all the evidence and make all the arguments. Where in an arbitration, it's an hour, 2 hours, 3 hours. You're giving a summary to the arbitrator of the testimony. You're giving some of the documents to the arbitrator, and the arbitrator not listening to testimony really, not really seeing the full picture, does the best he or she can. I mean, I've done non-binding arbitration. I've never felt that that's the same as hearing a case at trial. It's not the same. Whereas in our mediation, you can really go through the process. You can really start digging in and start to talk to people neutrally, objectively, privately, confidentially. Let's really take a look at this. And the mediation alternative is far preferable.
It sounds like mediation offers more of an opportunity to truly be heard. And when people are heard, that's when you're more likely to be able to come to some sort of a resolution.
Well said. Maybe I should be asking the questions.
Well, I want to switch back to your time on the bench. What are some of the more memorable cases you presided over? I think you had a case with former President Trump, did you not?
I did. In fact, I had more than one.
Wait, more than one case with Trump?
Yes, he took up a fair amount of my time over a 10-year period, actually. The first one dealt with the Hard Rock Entertainment Complex and Hotel in Hollywood. That took place over a period of time. Although that never went to trial, it settled a couple of times, but the final settlement actually held. And then the second one, that was my last jury trial in March of 2014. It dealt with what was going to be the Trump International Hotel on the Intracoastal in Fort Lauderdale, which is now the Conrad Hotel.
Was he the plaintiff or defendant in these cases?
He was a defendant, and he was successful. I will say, unfortunately, most of the cases that were memorable were because of the severe tragedy or the severe emotion of them. There was a time right near, in fact, the former office building for the law firm, Cypress and Andrews, where a CSX railroad plowed into a Hess tanker truck at the intersection of Andrews and Cypress during the middle of the afternoon that wreaked havoc. That trial was a very difficult trial. There was a gasoline tanker that flipped over at the area where I-595 and the Turnpike and 441 all converged. Again, a high tragedy.
I'm sure those type of cases are haunting, or that they stay with you.
Yes, and another one is one woman who lost her only child in an automobile accident. And what made it particularly tragic was that she was offered a sum of money that she could have created a monument or a foundation or a scholarship or something in her daughter's name. And it was a very difficult case, and she would not accept the money, and she was not successful in the case. So those type of things, unfortunately, stand out. But then there was good things. There were times when I was in the criminal court, people would come to me and tell me how well their child did or how this person had done during their probation and rehabilitation. I got to preside over adoptions. That was always a wonderful moment. But truly, the trials, unfortunately, that typically I remember the most vividly are those where there's tragedy. Although there's one trial somewhat is like Jeff Goldblum in Jurassic Park, chaos theory. It's the chaos theory that controls. Well, the fact is, sometimes things happen that I don't care how well you prepare, the unscripted will happen. And I'm in a trial over a claim brought by a business that was hit by Hurricane Wilma, a case against its insurance company for Wilma damages. And the adjuster who was handling it for the insurance company is on the witness stand. And for the first time, happens to mention that he was actually conducting surveillance of the insured somewhere in the bushes or somewhere, filming the operation of this business. And it was like everyone's eyes lit up, including the jury and the lawyers. Needless to say, the verdict was huge, huge, way beyond what the plaintiff would have settled before. Because once a jury, what you made a claim on your insurance, and they were videoing you.
Sounds like a Perry Mason moment that we refer to. You have said that there's no perfect case, that no result is ever certain, and every case has its risks. Does that blow a hole in some trial lawyers' egos, just like the situation you just described?
You have to have a strong ego to be a trial lawyer, period. You do not want a wimp representing you in the courtroom. That doesn't mean the person has to be obnoxious. It doesn't mean they have to be an ego out of control. And there are times when egos are a significant problem. And I do the best I can with that in mediation. I do the best I can with that in the courtroom. I can control it a lot better in the courtroom. I can't really control it in mediation. I don't have to. I just do the best I can with it. But by and large, I don't see that as an issue. When I was training, because once you become certified as a mediator, you have to observe a certain number of mediations, and you have to co-mediate with a mediator. And I remember speaking to one, and he asked me afterwards, he said, what's the most important thing for you to consider in your mediation practice? I said, well, trying to resolve a case. He said, no. He said, try to keep the lawyers happy because that way you make sure you have more business. And I think, well, I know you. I know why you said that. I don't mediate for the lawyer. I mediate to help the people. And I understand that there may be times where I will work with someone and they will settle, which they should, against the lawyer's advice. And I know that I probably will not see another case from that lawyer. And you know what? At night, I go to sleep so smooth.
That's okay if you've done your job.
Absolutely right, because I know that was a good settlement for those people. I can recall 2 instances in particular where, and both of them involved people losing a child, an adult child, but a child. One of them was his only child. And it wasn't about the money. It was about reaching a fair resolution to get some closure. And the lawyer saw big dollars. I didn't necessarily agree with that, but I knew there was a sum of money that I could get to that was reasonable, that father who lost his only son would be okay. And that's what happened. And I never saw another case from those lawyers. And I knew I wouldn't. That's okay. And another one was, it was a medical negligence case where a woman had suffered, but had improved. She was dealing with conditions, and her life was okay. She and her husband were still together. They were fine. The lawyers I'd worked with for years, they accepted it was a healthy 7-figure settlement. But the lawyers thought they could probably get 50% more than that. But that amount of money would have changed their life. It would have ended probably another 5 years worth of litigation, maybe including a potential appeal, that they might have gotten more. But they would have all that money now, and they were in their 60s. And the same thing happened. These are lawyers that I've worked with many times, either in court or as a mediator. I've never seen another case from them since. And that's okay, because that was the right result for that mediation, those people.
I think people lose sight of the fact that there's a value to their time as well. Litigation, particularly, I get a lot of board members occasionally that want to sue over defamation. Somebody has said something about them that they don't like. They've put it out to the community and they want to sue for defamation. Right. What I say to them is, look, those type of cases in particular are time consuming. They're hard to prove. They're costly. And there is a value to your time. You have to figure out how much of your life do you want to dedicate to this process.
Tell them to look up the General Westmoreland versus Time magazine case, where God knows how many years and how many hundreds of thousands of dollars were spent for a verdict of $1.
I do want to talk to you a little bit, Jeff. I know you haven't been on the bench for a while, but violence against judges is on the rise. I mean, we're seeing it across the country. We're seeing that play out right now with Judge Reinhardt, who is the judge who approved the FBI's recent search of Mar-a-Lago. How big a threat does this pose for our democracy that judges are now being targeted by people who don't like their decisions?
I will say that this is only one of several very disturbing developments that erodes our democracy. It is not unusual, though, for lawyers who make unpopular decisions to be criticized. I mean, our former president was really good at that. He attacked a number of judges whose opinions were critical of him. It's a very dangerous road to take. I don't know that it's going to dissuade people from wanting to be judges. It may create a situation where we have to step up our security for judges, which includes the attacks on some of the newer conservative judges on the U.S. Supreme Court for their decision dealing with Roe versus Wade. I understand the right to protest, but those judges need protection. It has nothing to do with my view of their views at all. But nevertheless, no judge at any level of court should be concerned about his or her survival based upon a decision they make. But this has been true. We've had, anytime a judge is asked to make a controversial decision, there's always that risk of media criticism, of public criticism. We've had it in Florida. We've had it in other states as well.
Do you think the potential for violence could result in some judges rendering rulings they otherwise wouldn't have?
Anything's possible. How do you rule that out?
But what a slippery slope if that's where we're headed, where judges are not basing rulings on the law and the evidence, but instead on the potential outcome and the backlash.
The fact is, judges are people. And that has always been a concern. Anytime you go in front of a judge on a hot political question, you're always running that risk. You're just hoping that judge is going to do his or her job, is to shut that off and just focus on the law and the evidence. But again, that's why our system is the best, but it's not perfect because we're people. We're not machines. It's not, okay, we have the right software, let's plug in the data, let's get the result from our iPad. We're people. But any hot button issue, you're always going to have a concern about the ability of the judge to have blinders on and just focus on the merits and not any outside source of concern.
Did you ever receive any threats while you were on the bench?
I was stalked.
Oh.
Yeah. I really didn't know the extent of it until a little bit after, but it was in a family law related matter. Family law is really a challenge, I will say. And I had one where a father had been estranged from his daughter, had nothing to do with his former wife and his child, and this went very early in my career on the bench, and he was a former military man, and tune changed when the mother finally said, "You know what? I've gone too many years without any support from you at all. I've got to go to court to get back support from you." And he lived like 10 minutes away. He would drive by their house all the time. No contact, zero contact, no birthday cards, no Christmas card, no nothing. But now that an effort was made to collect support, now I want visitation rights with my child. Well, this child at that point I think she was 15. And so I spoke to her and, of course, the mother. And my decision was, I'm not going to condition any support on visitation. I'm not going to order any visitation. When she's ready to see you, then that's her call. He was not happy. So all of a sudden, I'm in a jury trial, and he walks into the courtroom and just sits there and stares at me all day. I alerted my court deputy. I'm not going to remove him. Just keep an eye on him. And I happened to see, some months later, it was his former wife, because she was married to the guy at the time and already left him because he was dangerous. And she told me that he found out where I was living and had been driving around my house.
Oh, that must have been unnerving when you heard that. On a much lighter note, you're a former member of the Master Chorale of South Florida, and I understand that you sung with Andrea Bocelli. Before I let you go, you got to tell me what that was like.
It was an extraordinary experience. When Andrea Bocelli would appear in South Florida, he would appear with an orchestra of like 70 people. But he would also need backup vocals. 60 of us from the Master Chorale. The Master Chorale was like somewhere between 125 and 150 people. 60 of us were selected to sing behind him. And it was at the big arena in Sunrise where the Florida Panthers skate. And so you're looking at 19,000 people attending this concert. And it was really it sent chills down my spine, really, to be a part of that kind of sound. There's a tendency to want to oversing, really, just stay within yourself, blend in with everybody else, and be a part of what's being created. It was a great experience.
Jeff, I was probably in the audience listening to you because he always comes down around Valentine's Day. So I've gone to those concerts of his for a couple of years, years and years. And I remember going with my in-laws. So I was probably in the audience. I'll say you did a great job. I mean, he really puts on an amazing show.
Well, for me, to me, one of the most powerful opera pieces is Nessun Dorma I mean, just listening to
one of my favorites.
Saying that Nessun Dorma is like uplifting. And Andrea Bocelli is an extraordinary singer. He's not Luciano Pavarotti, however, but he is an extraordinary singer. But because we did Nessun Dorma in his concerts, it's one of his staples. And it was like, I can't believe I'm in this. This is like so unbelievable. Yeah, it was great.
Last question, and thank you so much for your time today. But so what's on the horizon for you? I know you're not finished because you keep going. Your career over the decades has been amazing, and there's been an evolution. So, are there new mountains to climb for you?
I am really happy mediating. It's, to me, the best conclusion. I don't see myself going back representing anybody. I've been asked. I choose not to get back into the active practice. I don't see myself going back to a law firm. I've not chosen to go back to judging. I've stopped. I was doing arbitrations. I've stopped doing that. I see this as the best conclusion to my legal career, and I'll stick with it as long as people want me.
I think people are going to want you for quite some time. Jeff, thanks for joining us today. Thank you for joining us today. Don't forget to follow and rate us on your favorite podcast platform or visit takeittotheboard.com for more ways to connect.